Think you own your art just because you made it? Wait till someone copies it, remixes it, or straight up sells it in a market with your name nowhere in sight. Welcome back to Legal Hoots. Last time we covered what copyright is. Today, the 5 copyright powers you actually control and how to use them like a pro. So smash that like button and subscribe to the channel. Let's dive in. Power number 1. Rights of a copyright holder. Picture this. You compose a beautiful song. Upload it on YouTube. Next week, it's playing in a wedding video. A restaurant, someone's Instagram reel, without asking you. Section 14 of the Copyright Act, 1957, gives you 6 exclusive keys. Nobody, and I mean nobody, can use these without your permission. Key 1. Reproduce. Make copies of your work, digital or physical. Key 2. Publish. Issue copies to the public for the first time. Key 3. Perform publicly. Play your song at a concert. Screen your film in a theatre. Key 4. Make films. Adapt your novel into a movie or web series. Key 5. Translate. Convert your Hindi poem into English, Marathi, Tamil, any language. Key 6. Adapt. Turn your book into a play, your article into a video essay. Bonus for software developers. You also control commercial rental. Nobody can sell or rent your program without paying you. Quick legal tip. The actual bundle of rights depends on your work's class. Songs get different rights than books. Films, different from art. Computer programs, different from photographs. Always check which Section 14 rights match your creation. Only computer programs get exclusive rental rights. Only musical works get public performance rights in specific ways. Do any of these without permission. That's copyright infringement. And remember, infringement covers even unauthorized streaming, display, or public performance. Penalties? Up to 3 years jail time and even monetary fine. Check Section 51 for the full list of what counts as infringement. Each right equals a revenue stream. License them wisely. Power number 2. How long does your copyright actually last? Here's what most people don't know. In India, it depends on what you create. Let's start with the big one. Books, songs, paintings, and scripts that constitute literary works. If you write a novel or compose a song today, your copyright lasts for your entire lifetime plus 60 years after you die. Live until 2080. Your work stays protected until 2140. That means your children and grandchildren can keep earning from what you created. Working with a co-author. The copyright runs for 60 years after the last surviving author dies. Now, films, sound recordings, and photographs work differently. For these, it's simpler. 60 years from the year they're published or created. Release a film in 2025. Protected until 2085. Your lifespan doesn't affect it. TV and radio broadcasts get 25 years from the date of broadcast. Here's the quick breakdown. Books, music, art, and scripts. Your lifetime plus 60 years. Films, recordings, and photographs. 60 years from publication. Broadcasts, 25 years. Bottom line, if you wrote it, composed it, or painted it, it outlives you by 6 decades. Create a hit song at 25, die at 85, and your family earns royalties until you would have been 145. That's not just legal protection. That's a legacy. That's generational wealth. Create once, protect smart, and let your work provide for generations. Power number 3. Transfer rules. The smart creator's business strategy. Real scenario. A music label offers you rupees 5 lakh for your song. Sounds great, right? But here's the catch. What are you actually selling? Sections 18 and 19 give you full control over how you transfer your copyright. You can sell all rights or just some. Only streaming rights, keep film rights. For all territories or just India, keep international rights. Forever or for 5 years, take back rights after contract ends. Exclusive or non-exclusive, multiple buyers possible. Section 19 makes it mandatory. Every assignment must be in writing and clearly state which work, what rights, which territories, how long, how much royalty. Verbal agreement, legally worthless. Here's a legal hack most creators miss. By default, any copyright assignment lasts for just 5 years, unless your contract clearly says otherwise. Section 19(5). If your contract doesn't specify duration, the assignment is legally valid for only 5 years. After that, unless extended, rights can revert to you. Always specify how long you want to give away your rights, or let the law protect you with this default. Critical difference. Licensing is not a sale. License. You keep ownership, just grant limited permissions, like renting out your property. Assignment. You transfer ownership for the agreed period, which can be permanent or temporary depending on your contract. Here's a pro move. License. Your song to an OTT streaming platform. For India streaming for 2 years. Keep YouTube rights. Keep international rights. Keep remix rights. 1 work, 5 income streams. This is how smart creators think. Power number 4. Copyright notice. That tiny copyright symbol that packs a punch. Quick question. Do you need to put copyright symbol on your work? Using copyright symbol isn't legally required for protection in India. Under the Berne Convention, which India joined in 1928, copyright protection is automatic and doesn't require formalities like registration or notice. Protection is automatic, but if your work hits YouTube, Instagram, or international markets, that symbol signals you know your IP stuff. Why smart creators use it? Reason 1, public declaration. Everyone knows it's protected. Reason 2, ownership proof. Your name is stamped on it forever. Reason 3, dated evidence. Proves when you created it. Reason 4, destroys the I didn't know defense. Someone steals your work and claims innocence. That copyright symbol is your proof they knew. The format is dead simple. Use it, always. Power number 5, automatic protection plus strategic registration. Here's the biggest myth about copyright. I need to register to be protected. Wrong. Listen carefully. Acquisition of copyright does not require any formal procedure. Section 13 confirms. Copyright subsists in original, literary, dramatic, musical, and artistic works. Protection is automatic once your work exists in tangible form. You write a song? Copyrighted. You paint a picture? Copyrighted. You code a program? Copyrighted. No registration needed for protection. But, and this is a massive but, registration changes everything in court. When you register at copyright.gov.in, Section 48 makes that certificate prima facie evidence. Prima facie equals court presumes you're the owner unless someone brings solid proof to the contrary. Scenario A, no registration, you. Your Honour, I created this song in 2023. Court. Prove it. Show drafts. Show emails. Show witnesses. Prove the dates. Scenario B, registered. You. Your Honour, here's my government certificate. Court. Prima facie accepted. Other party, you prove they're not the owner. The burden of proof shifts from you to them. Registration doesn't guarantee a win, but it gives you a massive legal head start. Cost? A few hundred rupees. Processing time varies. Typically several months to over a year depending on backlog and any objections raised. So apply early. Tier 1. Automatic protection the moment you create. Tier 2, strategic registration for courtroom superpowers. Use both. These were the 5 powers every creator in India must know. So here's my question to you. That song in your drafts, that story you're writing, that design you just finished, are you just creating, or are you protecting your empire? Hit subscribe for more. This is LegalHoots, making law simple, practical, and powerful. See you in the next one.